Good morning and a warm welcome to the 33rd meeting of the Constitution Europe External Affairs and Culture Committee in 2025. We have received apologies from Stephen Kerr and we welcome to committee Brian Whittle, who is not a substitute but is joining us for the Stage 2 proceedings. The next agenda item is a decision on agreeing to take business in private on our consideration of the Stage 1 report on the Desecration of War Memorials Scotland Bill at a future meeting. Are we all agreed? Thank you. The next agenda item is to consider the UEFA European Championship Scotland Bill at Stage 2, and I welcome Richard Lockhead, Minister for Business and Employment, and his officials to the meeting this morning. We now move to the Stage 2 proceedings, and if we can go straight ahead, the first question is that sections 1 and 2 be agreed. Are we all agreed? If members could speak up since it's voting for. Thank you. Thank you. We now move to section 3, ticket touting, and I call Amendment 3 in the name of Stephen Kerr, grouped with Amendment 4, and invite Jamie Hacker-Johnson to move Amendment 3 and speak to both the amendments in the group.
Thank you, Convener. And I'm speaking on behalf of Stephen Kerr to his amendments 3 and 4 in this first group on ticket touting. These amendments are modest, reasonable and entirely consistent with the committee's Stage 1 findings, but they address two important weaknesses in the bill as drafted: proportionality in the treatment of community fundraising and the bill's limited ability to deal with online and cross-border touting. Amendment 3 deals with proportionality. The bill exempts charities from touting offences, but it draws that line too narrowly. Across Scotland, community-controlled bodies, parent councils, community councils and schools routinely raffle or auction donated tickets to raise funds for pupils, for local facilities and for other causes. These groups are not commercial enterprises and they're certainly not touts. Their activities fall squarely into the category of legitimate, socially beneficial fundraising. Yet, as drafted, the bill would criminalise these activities if a school or community body sought to raise money by offering donated tickets. That cannot be what ministers intended. And Amendment 3, therefore, expands the exemption in a controlled and responsible way, recognising that community fundraising is not the target of that legislation. Convener, the committee stressed during Stage 1 of the bill that the bill must avoid overreach while still satisfying UEFA's requirements. This is a clear example of where a small adjustment avoids an unnecessary and unintended consequence without compromising the integrity of the touting ban. Amendment 4 addresses a different concern: the territorial limits of the bill's enforcement. Much touting now takes place online, routed through platform and sellers who may be operating elsewhere in the UK or abroad. The bill, however, regulates only what takes place in Scotland. The evidence we heard made it clear that this creates a potential weakness in enforcement. And Amendment 4 does not prejudice the right solution, nor does it impose obligations on other governments. It simply requires Scottish ministers to report formally on the steps they've taken to secure intergovernmental cooperation, including with the UK Government, the Welsh Government and the Government of Ireland, and to report early enough for any gaps to be addressed before the championship period. If the government is already engaging formally, then it should have no difficulty in setting that work out transparently to this committee and to Parliament. If it is not doing so, then the need for this amendment is all the greater. Both amendments are constructive and proportionate. They ensure that the bill does what it's supposed to do: stop touting that exploits fans, without inadvertently criminalising schools or community groups, and without leaving enforcement gaps that undermine the purpose of the legislation. I'd invite the Minister to respond clearly on these points and to consider accepting the amendments which I move.
Do any committee members wish to speak? No. Can I invite the Minister to speak to the amendment?
Convener, in lodging Amendment 3, Stephen Kerr is seeking to widen the exceptions for ticket touting in a way that risks increasing scope for exploitation by touts. The purpose of this touting offence in the bill is to stop those looking to resell Euro 2028 tickets for their own gain. We must therefore seek to keep resale exemptions as tightly drawn as possible to avoid creating easy loopholes that some may try to exploit. The current provision in the bill ties the charity auction exception to charity registers where they exist. This provides strong assurance that those claiming the exemption are indeed charitable in nature, and that any funds raised will be used entirely for charitable purposes. It also provides a clear way through the published register for enforcement bodies to identify whether an organisation seeking to utilise the exemption is eligible to do so. Assurances would not be as strong in the exemptions if it's widened to include the bodies in the amendment. For example, there is no central register for community-controlled bodies, making verification more challenging. Also, the legislation that defines community-controlled bodies, the Community Empowerment Scotland Act 2015, does not set out to regulate these bodies and their use of funds. It may therefore be difficult to establish that monies raised from the auction are used solely for charitable purposes. Many Scottish schools and community groups are already themselves charities or are associated with registered charities and would therefore be able to benefit from the exemption as it stands. Of course, it's open to those that are not currently registered to consider if they're able to do so, and after all, they have until 2028 to do so. For example, we know there are already over 400 Scottish charities associated with publicly funded schools. This includes parent-teacher associations, parent councils, after-school clubs, extracurricular groups and uniform banks, etc. So it would be untrue to say that local groups cannot register as charities. Over half of the charities registered in Scotland work within their local areas. Over 2/5 operate locally at a specific place, community or neighbourhood. Sure.
Just really on that point, I mean, we're talking about registering here. Is there a concern, though, that some organisations may fall foul because they're not aware that they have to register in this case? And also, ahead of on that same point, I suppose, what information will the government provide? Will there be any kind of advice, guidance given in terms of ensuring that organisations do fall within the law?
I'm happy to give further consideration to how we advertise the charity exemptions to alert any potential organisations that they can take advantage of this, and we certainly give some thought to that. But in terms of the legislation, as I'm outlining there, it's got to be tightly controlled. Can I also say that, nor would it be true to say that small groups cannot register over one quarter of Scottish charities have an income of less than £5,000. 2/3 have no paid staff and are run by volunteers. So Amendment 3 increases the risk that the exemption could be exploited by those who claim to be raising funds for charitable purposes, but are in fact seeking a profit. The Scottish Parliament has previously legislated in charity regulation, in part to give us exactly the assurance we need here, that we can have confidence in how the funds are raised and used. Further, Section 3 of the Bill currently includes conditions which, if satisfied, enable charities based out with Scotland to benefit from the exemption, ensuring there is no discrimination between Scottish and other charities. Amendment 3 does not include a mechanism to determine whether bodies equivalent to community councils, for example, should benefit from the exemption. Turning to Amendment 4, we have a track record of producing bespoke legislation for major events in Scotland. We have done so again here to meet UEFA's requirements in accordance with UEFA's timetable and within parliamentary time constraints around the 2026 elections. We are in regular discussion with the governments of other host nations to ensure a coherent approach. We understand that the Welsh Government and Northern Irish Executive have no plans to introduce primary legislation. The Republic of Ireland has existing legislation prohibiting ticket touting. The UK Government has indicated that it's still working through how best to deliver UEFA's requirements. So I know that committee members will be interested in the UK Government's announcement last month as well, that they intend to explore possible legislative solutions to live event ticketing and touting more generally. And of course, we will continue to engage with the UK Government as their proposals take shape to address this and the issues around dynamic pricing and so on. However, it's not for Scottish ministers to make announcements for other hosting governments. As such, we cannot commit to providing a meaningful report to Parliament within the timeline this amendment sets, nor would it be in our gift to remedy that. There is a possibility that the UK Government legislates for its jurisdiction beyond the proposed timeline for reporting. So instead, I propose that Amendments 10 and 12 relating to the review of the Act to be debated later provide assurances that the Scottish Government will report to Parliament on engagement with other governments of host nations as part of the reporting on the impact of the legislation. So I therefore encourage members to resist Amendments 3 and 4.
Thank you, Minister. Can I invite Mr Halker-Johnson to wind up or withdraw, press or withdraw his amendment?
Thank you, Convener. I mean, as I say, I'm speaking to Stephen Kerr's amendments, I understand that Mr Kerr, and obviously Mr Kerr and yourself and Mr Whittle and I have met with you, and I think Mr Kerr would be happy to discuss further if you're happy. And so on that basis, I'll withdraw the amendment.
Thank you very much. The question... Our members has indicated that they wish to withdraw the amendment. Does any member object? No member has objected, so the amendment is withdrawn. And the question is that Schedule 1 be agreed. Are we all agreed? Sorry. Can I... It's been a while since I did this, Minister. Sorry. The question is that Section 3 be agreed to. Are we all agreed? And the question is that Section 4 and 5 be agreed. Are we all agreed? And the question is that Schedule 1 be agreed. Are we all agreed? Thank you. Call Amendment 4 in the name of Stephen Kerr, already debated with Amendment 3, and ask Mr Halker-Johnson to move or not move.
Not move.
Thank you. So the question is that Section 6 be agreed. Sorry. The question is that Section 6 be agreed. Are we all agreed? The question is that Schedule 2 be agreed. Are we all agreed? And the question is that Section 7 to 10 be agreed. Are we all agreed? I call Amendment 5 in the name of Jamie Halker-Johnson, grouped with Amendment 11, and I invite Jamie Halker-Johnson to move the Amendment 5 and speak to both amendments in the group.
Thank you, Convener, and I'll speak to Amendments 5 and 11, which are in my name, on compensation for existing street traders. These amendments arise directly from the evidence this committee took at stage 1, and they reflect a real concern held by traders who operate lawfully and who will be significantly affected by the restrictions in this bill. The bill requires Glasgow City Council to offer alternative trading arrangements to licensed traders who are displaced from the event zones. On paper, well, that sounds reasonable, but in practice, as we've heard, these alternative sites may be well away from fan zones, from the stadium, and well away from the busy routes where traders would normally expect to earn the bulk of their income. Being moved from a prime location to a low footfall site is not an alternative in any meaningful commercial sense. And for many traders, particularly small independent operators, that could mean losing the most lucrative trading days that they could have had in years. Convener, it's important to be absolutely clear. These restrictions are not being imposed for reasons of public safety, nor because of the needs of the city or to support local community. They are being imposed to meet the commercial requirements of UEFA. They're there to protect the exclusive rights of global sponsors, and if those requirements force small Scottish traders off pitches they've operated for years, then it should not be the Scottish taxpayer who bears the cost. Amendment 5 therefore requires ministers to make formal representation to UEFA seeking funding for a compensation scheme that reflects the genuine loss of revenue traders may face. It also ensures that any scheme can operate only if UEFA funds not just the compensation itself, but the full administrative costs of running it. That's essential, and we cannot have a situation where public money is being quietly used to underwrite UEFA's commercial model. Amendment 11 is a simple consequential amendment ensuring the regulation making powers aligns with that scheme should UEFA agree to fund it. Traders are not asking for special treatment, they are asking for fairness, and they're willing to adjust, and they recognise the importance of hosting major events. But they should not be asked to absorb financial losses created solely to protect the interests of a large Euro organisation. These amendments provide a balanced and reasonable way of addressing that injustice, and I invite the Minister to confirm whether the Government has already made any such representations to UEFA, and if not, why not, and to consider supporting these amendments. I move for the amendment.
Thank you. Do any members wish to take part? Mr Harvey?
Thank you, Convener. I can understand why Jamie Halker-Johnson thinks that where, in specific instances where traders have made a loss, that might be compensated. But there will also be significant circumstances in which traders gain additional opportunities in other places, perhaps, but opportunities that wouldn't have been there if the tournament hadn't been happening. Can I ask Jamie Halker-Johnson, either intervening now or in his closing comments, is it his view that the government ought to try and establish a situation where there are no losses and no benefits? And in which case, how does he intend to recoup the additional benefits that will be gained? Or is he trying to suggest that losses should be compensated and benefits should be pocketed.
Yes, I'm happy for you to.
I think Mr. Harvey makes an important point, but I think the concern that we have is that there will be benefits, obviously, to the city. There will be benefits to many businesses in the city, but these are specific sites that certain traders have operated for a considerable amount of time, and they will not be benefiting to the same extent, or that may not benefit at all if they're losing those particular sites, and that's the concern. Overall, there will be benefits, of course, to the city and many businesses, but certain traders may lose out because of this, despite all the tourists, all the visitors, all the football fans coming in. I think this is where we have a concern.
Just finish by saying I'm unclear how it is that Jamie Halcrow-Johnson thinks that if street traders are being moved from one site to another, how we can disaggregate the losses from the benefits and develop a compensation scheme that couldn't be pretty ruthlessly taken advantage of.
Can I begin, Mr. Brown?
Yeah, just to say, I'd be interested to know, Mr. Halcrow-Johnson says what traders are asking for. What process has been followed to find out what traders have been asking for? And also, I think we heard in earlier sessions, I think Neil Bibby made the point that this is pretty much a take it or leave it kind of deal that you have with UEFA. They kind of call the shots in relation to this if you want to host those championships. So do you not feel that this is a pointless amendment in that regard?
I'll come back at the end.
Come back at the end. That's fine. Can I bring in the Minister, please?
Convener, it's important that small businesses, including street traders, can benefit from the opportunity of hosting Euro 2028 in Scotland. We want to make things as easy as possible for those affected by event zones. That's why the bill makes sure there will be guidance about the measures that will be put in place. It also makes sure that street traders who can't trade where they normally would be offered alternative arrangements. For example, the licensing authority may waive the application fee for a temporary licence at an alternative location for those whose current licence would normally allow them to trade in the event zones, but because of this legislation would not be able to do so. So these measures are consistent with the legislation that the Scottish Parliament passed for Scotland to meet the conditions of Euro 2020 matches. And I understand that Glasgow City Council has provided reassurances on some of these points directly to the committee. It has indicated that the Council's Street Trader webpage makes potential applicants and licence holders aware of possible trade restrictions that may come into force for the tournament. However, compensation can only be paid where there is an actual loss. As a one-off tournament, the Euro 2028 matches at Hampden Park will be an opportunity over and above what street traders could expect in any other year. Nor are street traders being prohibited from trading outright during the rest of the tournaments. So, as I've stated, we are putting measures in place to support them to trade out with the event zones. We, of course, will continue to work with Glasgow Life, Glasgow City Council and other partners to involve local businesses and communities in the delivery of Euro 2028. But we are in agreement with UEFA and UK and Ireland 2028 Limited on this point, that there is no loss to be compensated. There is therefore no basis upon which to make the kind of representations to UEFA that Amendment 5 seeks to require. So I thank Jamie Halcrow-Johnson for setting out his rationale for these amendments 5 and 11, but hope he might now agree that they are not needed and not to press them. Should he do so, I would encourage members to resist Amendments 5 and 11.
Thank you, Minister. Can I invite Mr Halcrow-Johnson to wind up and press or withdraw his amendment?
Thank you very much. Just following on those points that the Minister makes there, I mean, I think he said that there's no loss to be considered. We don't know that. And I mean, if you moved any business away from, say, a city centre location to an alternative location, that alternative location may not be as beneficial to them as their existing location. So saying an alternative site doesn't necessarily mean it's a site that's going to mean that they're able to do the same business that they were going to do, even with perhaps large numbers. And given that some of these, some of the fan zones, others will have other competition in prime locations, I don't, I'm afraid, accept that the alternative locations or the guarantees that the alternative... Of course, yeah.
It's just more a point of clarification, and I know everybody will laugh to say all roads lead to Paisley, but they do. Recently, St Mirren have been in the cup final on Saturday, and a street trader has appeared out of nowhere where there wasn't one before, and he's doing a reasonable trade both in the town centre in a pitch, and he's quite mobile. He's at the games as well, and he's never there normally. So is it not the case that these businesses tend to be the entrepreneurial spirit of these individuals, that they will find a way to make sure that they can sell their goods?
Well, I applaud Mr Adams for getting St Mirren into this conversation so early. But I think the point he makes about a mobile street trader is very much the point. A mobile street trader can go where they feel the business. This is a restriction on being able to go where the business is, whether it's a one-off or whether it's a traditional. Of course, yeah.
Glasgow will be the venue, not just Hampden Park. That's the scenario. They'll be all over Glasgow.
I recognise that, but I'm sure Mr Adams would also accept that not every part of Glasgow will be as busy as some parts. Therefore, you know, it's not the same to say that any site in Glasgow would be, and I think that's our concern with this. And just to kind of pick up some of the other points that was made, I mean, Mr Brown said this is a take it or leave it, and I think that's the problem. It shouldn't be a take it or leave it. This is the point of this bill and our scrutiny here, to make sure that we are looking out for the interests. We all accept, I think, that this is going to be a fantastic event. It's going to bring huge opportunities. But we also have to look at those that, if not maybe losing out, may be impacted by it. And I think that's what we're looking to do here. I appreciate all the points that have been made. As I said, I'm happy to work with the Minister further and have further conversations on this, because I do think there is an issue here that we need certainly to look at in more detail. And if the Minister's happy to meet further with me on this. Yes, of course.
Thank you for taking the intervention, if that's how it works. Happy to have further discussions, just to reassure Jamie Halker-Johnson about that. Obviously, we've got a range of concerns over setting this precedent, which would be a precedent that would potentially apply, therefore, to future major events that Scotland's holding, and how you define loss. Obviously, I'm making the argument there is no loss, but even if you were to accept there was some kind of loss, how would you define what the compensation would be? I think there's a range of issues there that would set a very, very unfortunate precedent and lead to lots of complications. But I'm happy to discuss these issues further with the member.
Mr Halker-Johnson to press or withdraw his
amendment? On the basis of having further discussion, I'm happy to withdraw.
Does any member object to the motion, the amendment being withdrawn? No, thank you. So the question is that section 11 is to be agreed. Are we all agreed? Thank you. Call Amendment 6 in the name of George Adam, grouped with Amendments 7 and 1. George Adam to move Amendment 6 and speak to all amendments in the group.
I'll be quite concise, Convener, because at stage 1 I believe there's a clear line drawn. Commercial activity can be restricted, but social or political activity should not be, even with commercial brands that are involved. I'm pleased that the Government agrees with this, and I thank the Minister for engaging with me constructively in the matter. These amendments protect fundamental rights by ensuring that the exemption for demonstrations cannot be stripped away later by regulations. And there's also a need to deliver the bill's core purpose, safeguarding UEFA's commercial rights, and Amendment 1 does that, and I'll be supporting that in itself. So with that, I move Amendment 6.
Thank you, Mr Adam. Can I invite the Ministers to speak to Amendment 1 and the other amendments in the group?
Convener, I agree with the committee's Stage 1 report that we must protect our civil rights to protest. That's why we made sure the activity would not be caught by the bill and its advertising offence at introduction, and Amendments 6 and 7 make this clear. I welcome these amendments in the name of George Adam, which signal the special value we place on protecting these rights, and obviously hope that members will support them. Turning to my own Amendment 1, the bill is essential to meet UEFA's commercial rights and the protections and the requirements to allow Scotland to host UEFA Euro 2028 in Glasgow. So part of this requires us to make unauthorised advertising an offence in designated areas. The bill seeks to take a proportionate response to restricting outdoor advertising. One of the ways it does this is by allowing existing advertising to remain in place so long as it does not be in direct competition with one of the tournament's sponsors or commercial partners. These areas of competition are identified in a list of product categories at paragraph 5.3 of Schedule 3 of the Bill. At its core, the exemption for existing adverts is a provision that we negotiated with UEFA for Euro 2020, which now needs updating so that it can continue to meet UEFA's hosting requirements. Engagement with UEFA since the Bill's introduction has identified some additional categories that need to be included if the provision is to operate as intended. Amendment 1 gives effect to this by amending the list at paragraph 5.3. So I ask the committee to support Amendment 1 so that this bill can fulfil its primary function, which is meeting UEFA's hosting requirements and in so doing enabling Euro 2028 matches to be held in Scotland with all the attendant benefits that will accrue from that.
Thank you, Minister. Can I invite any members who wish to speak? Mr Harvey.
Thank you, Convener. Just to welcome the fact that there's clear agreement across both the committee and the government, but drawing the distinction between commercial activity and social or political expression. Welcome the amendments from George Adam and the government's support for them.
Mr Brown.
A very quick comment to say I think the previous amendments we just discussed and this one are a way of trying to find the right kind of, if you like, line to be drawn. And I think we're going to face this again. There's a bid apparently from the government to look at a bid for the Women's World Cup to be held potentially in Scotland as well. And I don't know what restrictions we'll face from FIFA in Scotland's participation in the World Cup coming. So I think on the one hand, we're right to try and avoid precedents which would find it hard to repeat, but on the other hand, to find the right balance between people's rights and the imposition of whatever UEFA or FIFA do. So I would support the amendments.
Thank you, Mr Brown. Anyone else? Can I invite Mr Adam to wind up and press or withdraw Amendment 6?
I press Amendment 6 and I've got nothing else to add.
Thank you. The question is that Amendment 6 be agreed. Are we all agreed? Thank you. I call Amendment 7 in the name of George Adam, already debated with Amendment 6, and invite George Adam to move or not move. Move. Thank you. The question is that Amendment 7 be agreed to. Are we all agreed? Thank you. The question is that Section 12 be agreed. Are we all agreed? Thank you. Call Amendment 1 in the name of the Minister, already debated with Amendment 6, and invite the Minister to move formally.
Moved.
Thank you, Minister. The question is that Amendment 1 be agreed. Are we all agreed? Thank you. The question is that Schedule 3 be agreed. Are we all agreed? Thank you. The question is that Section 13 to 21 be agreed. Are we all agreed? Thank you. I call Amendment 8 in the name of Stephen Kerr, grouped with Amendment 9 and 2, and invite Jamie Halcrow-Johnson to move Amendment 8 and speak to all amendments in the group, including Amendment 9 in his own name.
Thank you, Convener. I'll speak to amendments in the Enforcement Powers grouping, standing in the names of Stephen Kerr and myself. These amendments seek to bring proportion, clarity and essential safeguards to what are some of the more intrusive and far-reaching powers contained in the bill. At stage 1, the committee heard repeated concerns about the breadth of the enforcement regime, its powers of entry, search, seizure, concealment and even destruction of property. These concerns did not come from fringe voices. They were raised by legal experts, civil liberties organisations and those with practical enforcement experience. The message was clear. These powers may be justified in principle, but the bill as drafted lacks the necessary checks and balances to ensure their fair use in practice. Amendment 8, lodged by Stephen Kerr, takes a straightforward and entirely reasonable step. It ensures that where an enforcement officer enters premises, the occupier has the right to request an explanation, to observe what is being done, and where they believe entry to be unlawful, to raise that concern with Glasgow City Council. These are not dramatic interventions, they're basic principles of natural justice. The right to know why enforcement officers have entered your property, and the right to witness the actions being taken. Without such safeguards, the balance of power is tilted too far in favour of enforcement officials acting on behalf of UEFA's commercial interests rather than the public interest. Amendment 9, standing in my name, addresses one of the more troubling aspects of the bill, the use of reasonable force. As drafted, the use of reasonable force to enter a property without a warrant can be used if, and I quote, the constable reasonably believes that there is a real and a substantial risk that delay in seeking a warrant would defeat or prejudice the purpose of taking action. I believe this is far too broad. The lack of a warrant should only be used in the most severe circumstances. My amendment therefore restricts the ability to enter a property without a warrant only when there is an immediate risk to public safety. It brings the power back into proportion, ensuring it is used only when genuinely necessary. These amendments do not impede the ability to enforce the bill effectively. They do not weaken the protection that UEFA requires. What they do is ensure that when the state grants coercive authority to individuals acting on behalf of a commercial event, that authority is exercised transparently, accountably and proportionately. If ministers are confident that the enforcement regime is already balanced, then they should be able to explain clearly why basic safeguards such as these are not acceptable. If they cannot, then that's an argument for the amendments themselves, and I'd invite the Minister to respond.
Minister.
Convener, Amendment 2 is a technical amendment to define the term constable. Making this link to the relevant existing definition in the Police and Fire Reform Scotland Act 2012 ensures absolute clarity of who can and who cannot use powers that the bill makes available to constables. I hope that members will be able to support it. I've listened carefully to Jamie Halcrow-Johnson's moving Stephen Kerr's amendments as well, setting out why he has lodged Amendment 8. This would give the occupier of a place entered or the person who gave permission for it to be entered certain rights. The bill, as currently drafted, already contains a number of safeguards on the use of enforcement powers. These are based on previous experience from major events and were developed with input from Police Scotland and Glasgow City Council. Government officials undertook this engagement to ensure that measures are workable in practice. However, Mr Kerr appears to be seeking further safeguards. In paragraphs 8 and B, he is seeking to have the occupier of premises informed why the premises are being entered and searched and to allow them to be present for the search. Recent engagement with Police Scotland has confirmed that this amounts to good practice. And while not necessarily essential to put this on the face of the bill, it is possible. However, we'd want to get views from Glasgow City Council before making any final decision on this. So, for that reason, I cannot support Amendment 8 as currently drafted, based on paragraph C. There is a question of whether the report of an unlawful entry in paragraph C of Amendment 8 should be more appropriately be made to Glasgow City Council or to Police Scotland. So it would not be appropriate to proceed with the amendment when this is in doubt. It could create a wrong expectation about what action might be taken if someone thinks that an unlawful entry has taken place. Moreover, both Police Scotland and Glasgow City Council have existing mechanisms for making a complaint if that is what is sought by the person subject to enforcement action. So I would ask Jamie Halcrow-Johnson on behalf of Stephen Kerr not to press Amendment 8 to allow more time for consultation with operational partners, especially Glasgow City Council, and to consider whether an amendment covering points A and B might be possible at stage 3. In terms of Jamie Halcrow-Johnson's amendment to Amendment 9 to the powers to use reasonable force to enter a premise for the purpose of carrying out enforcement action, it may help to explain the policy rationale behind these powers. Enforcement officers must be able to take swift action to tackle offences under this bill. The bill allows a police constable or enforcement officer, when authorised by a police constable, to use reasonable force in situations where the police constable reasonably believes that there is a real and substantial risk that delay in seeking a warrant would defeat or prejudice the purpose of taking action. If this power can only be used in situations where there is an immediate risk to public safety, it would severely harm or restrict the ability of enforcement officers to take action such as that to secure evidence before it could be destroyed or to investigate crimes under this bill. This could undermine the core purposes of the entire bill. I therefore think it would be unworkable in practice in terms of enabling enforcement action to be taken, and there is a risk that it undermines confidence in the event. For these reasons, I can't support Amendment 9 and ask members to resist it.
Thank you, Minister. Do any committee members wish to take part in the debate? Mr Harvey.
Thank you. It's perhaps a bit out of character for me to say that an amendment in Stephen Kerr's name seems reasonable. But I have to say, on first reading, I didn't see anything that appeared particularly harmful. But I think, having thought about it a little more, the rights that are being set out could, in some circumstances, be problematic. The right to observe searches, for example, if this conflicted with a situation where an individual was being disruptive or posed a threat to others around them, I think there could be some disputes, some unnecessary disputes about that. And also the point about reporting entry to the Glasgow City Council, I think, as the Minister referred to, I'd be a bit worried that that raised expectations, that the City Council would always have the ability to do something about that. And I'm not entirely clear how that would be helpful. So I don't think the amendment is one that should be supported. And I think for the reasons that the Minister set out, I'd have problems with Amendment 9 as well, in terms of the risk that the opportunity would be taken to destroy evidence.
So I invite Jamie Halcrow-Johnson to wind up and press or withdraw Amendment 8.
Thank you very much. Just responding to Mr Harvey's comments, I'm sure Stephen Kerr, wherever he is, will be as alarmed as you are by that almost consensus there. But I do take on those points, and I'm sure he would too, as has probably been the theme. I'm sure Mr Kerr, in fact I know Mr Kerr would be happy to work further with you on that, because there does seem to be some agreement and area for that. I do appreciate the concerns you raised, and I do recognise the concerns Mr Harvey also made there in terms of my Amendment 9. I do, however, feel that as I say, these are often, the situations often be one of commercial interest, and so that force does have to be reasonable. I'm not sure that is covered in the bill, and that's why that amendment came through with consultation with others. Again, I'm happy, as we will be talking about all of these amendments, to include that in that conversation if the Minister is happy to do that on both those amendments. On that basis, therefore, I won't press. So
the Amendment 8 has been withdrawn. Does anyone object to that being withdrawn? No. So the question is that Section 22 be agreed. Are we all agreed? The question is that Section 23 be agreed. Are we all agreed? I call Amendment 9 in the name of Jamie Halcrow-Johnson, already debated with Amendment 8. Jamie Halcrow, to move or not move?
I'll not move.
Not move. So the question is that Section 24 be agreed. The question is that Section 25 to 29 be agreed. Are we all agreed? Thank you. The question is that Schedule 4 be agreed. Are we all agreed? Thank you. And the question is that Section 30 to 34 be agreed. Are we all agreed? Thank you. I now call Amendment 13 in the name of Brian Whittle, grouped with Amendments 10 and 12. Brian Whittle to move Amendment 13 and speak to all amendments in the group.
Thank you, Convener. Can I start by thanking the Minister for his early and regular engagement on this bill. My concern arose from the wording within Section 22 around the power to enter and search, the bill around search and seizure of counterfeit goods, or as the bill describes them, infringing articles, during a meeting with the Minister to discuss this bill. While obviously I'm not opposed to seizing or destroying illegal material, I think it's important to make clear the definitions and interpretations of this legislation and the processes to act to prevent overreach and threats to legitimate traders. This bill makes clear on the face that ticket touting, trading within the event zone at prohibited times and advertising within an event zone within prohibited times is an offence. However, there are also many exceptions written into the bill. In addition, I acknowledge that UK law makes it illegal to produce and sell counterfeit goods, but it is not listed as an offence on the face of this bill, which creates, in my mind, an uncertainty around this, if this is a championship offence as defined in the bill. For reference, the championship offence is described in the bill as having the meaning given by in Section 18(1)(a) around the general enforcement powers. And it says there that an enforcement officer may take such reasonable steps as an officer considers necessary for the purpose of preventing or ending the commission of an offence under this Act, i.e. a championship offence. What I'm trying to do with this amendment is to ensure that there is guidance around what constitutes a championship offence and gives clarity to Police Scotland and councils on what they should act on and how they should act on. Convener.
Thank you. My apologies. Can I invite George Adam to speak to Amendment 10 and the other amendments of the group?
Thank you, Convener. I seem to be continually following Mr Whittle, but that would always have been the case. Even in his advanced years, he would still be way in front of myself. But the committee recommended that the Scottish Government work with Glasgow City Council to monitor and report the bill's human rights impacts. Amendment 10 and the consequential Amendment 12 ensure that the Scottish Government reviews and reports on the Act's provision in a timely manner. It will also ensure that those enforcing the Act will be involved in that review, and importantly, it sets a deadline for completion of that review. So I hope, therefore, that members can support Amendments 10 and 12.
Thank you. Can I invite any other members who wish to take part in the debate? Thank you. Can I invite the Minister to speak to the amendments?
Convener, turning first to Amendment 13 in Brian Whittle's name. The meaning of championship offence is already given in the bill itself. Section 18(1)A of the bill sets out that championship offence means an offence under the Act. No further guidance should be required. In any case, it's not usual practice for Scottish ministers to issue guidance about the meaning of new criminal offences. The Scottish Government, along with our partners, will seek to raise awareness of the bill and its offences, as is usual practice. Linked to that, there is already a duty for Glasgow City Council to issue guidance about trading and advertising in event zones to help businesses and the public understand the provision. In terms of enforcement action, it will be for Police Scotland and Glasgow City Council, as well as the Lord Advocate and the Crown Office and Procurator Fiscal Service, to consider how best to investigate, enforce and prosecute offences in the bill. Providing detailed guidance to these bodies on operational matters is not the role of the Scottish Government. So I therefore ask the committee to resist Brian Whittle's Amendment 13. Turning to Amendments 10 and 12 in George Adams' name, we are already working closely with our delivery partners on the bill's provisions and how they will be evaluated. Given the committee's strong interest in the potential impacts of the bill's provisions, we are happy to support these amendments. We will continue to work closely with our delivery partners to report in a timely manner, and these amendments will underpin our undertaking to do so.
Can I invite Mr Whittle to press or withdraw Amendment 13?
Thank you, Convener. I have to say that I think there's ambiguity here in the definition of a championship offence as opposed to UK law. I think it's incredibly important that that is defined, and for that reason, Convener, I'm going to press.
Whittle, the question is that Amendment 13 be agreed to. Are we all agreed?
Yes.
No. So we move to division. Those members supporting the amendment, please raise their hand now. Sorry.
I'm not looking at you.
And those against the amendment? So the result of the vote is 1 for, 5 against and no abstentions. So the amendment is disagreed. Thank you. Can I call Amendment 10 in the name of George Adam, already debated with Amendment 13. George Adam, to move or not move?
Moved.
The question is that Amendment 10 be agreed to. Are we all agreed? Yes. Thank you. The question is that Section 35 be agreed to. Are we all agreed? Thank you. Call Amendment 11 in the name of Jamie Halker-Johnson, already debated with Amendment 5. Invite Mr Halker-Johnson to move or not move.
Not moved.
Thank you. The question is that Section 36 be agreed to. Are we all agreed? Call Amendment 2 in the name of the Minister, already debated with Amendment 8, and invite the Minister to move formally.
Moved.
Thank you. The question is that Amendment 2 be agreed to. Are we all agreed? Agreed. Yes. Thank you. The question is that Section 37 be agreed to. Are we all agreed? Agreed. Thank you. The question is that Section 38 be agreed to. Are we all agreed? Agreed. Thank you. Call Amendment 12 in the name of George Adam, already debated with Amendment 13. George Adam, to move or not move?
Moved.
Thank you. The question is that Amendment 12 be agreed to. Are we all agreed? Thank you. The question is that Section 39 be agreed to. Are we all agreed? The question is that Section 40 be agreed to. Are we all agreed? Thank you. And the question is that the long title be agreed to. Are we all agreed? Thank you. And that ends Stage 2 consideration of the bill, and we'll pause just to let the Minister and his officials leave the room. Thank you very much for your attendance this morning. Good morning and a warm welcome back to the Constitution Europe External Affairs and Culture Committee. Our final agenda item today is to continue taking evidence on the legal mechanism for any independence referendum. And we're joined in the room, and I hope I get names right, please correct me if I'm wrong, Professor Nikos Skoutaris, Professor of European Constitutional Law, University of East Anglia, Dr Leah Reibel, School of Law, University of Glasgow, and Professor Ailsa Henderson, Professor of Political Science at the University of Edinburgh. We are also joined online by Professor Aoife Donoghue, School of Law at Queen's University Belfast, and again it's the second week in a row we've had a guest from Canada. Thank you very much for the early rise to Professor André Lecours, Professor of Political Studies at the University of Ottawa. And I thank you all for the written contributions. They've been very, very helpful to our deliberations. So we have heard so far an evidence-taking, and especially in the wake of the Supreme Court ruling, that the Scottish Parliament does not have the competence to legislate for another independence referendum. Is there merit in seeking to formally establish the circumstances in which a referendum could take place? And additionally, do you have any views on what the legal framework or procedure could look like or could be arrived at? And if I could go left to right in the front here, if I go to Dr Reibel first, please.
Right, thank you very much. In short, yes, I think there is merit in establishing what a procedure would look like, because matters of process are really important when it comes to securing, in particular, losers' consent, so that the losing side is also prepared to accept any result coming out of a process. This is important not just after a referendum, but it is also important before. So it's important to remember that there are losing sides both now and after. They may be the same ones or not, as the case may be, but they both exist nevertheless. And as I said in my written submission on what I think any regulation should look like, both evidence from international experience, and I'm sure my colleague Professor Henderson will say more about that, public opinion, actually point to a mechanism that establishes more autonomy for Scottish institutions than what is currently the case. This is because a tight hold on process questions by the parent state, the metropolitan state of any entities that have or have some secessionist pressures within them seems to further instability rather than stability. This is perhaps a bit counterintuitive, but it's quite conclusive in my view. Thank you.
Thank you. Professor Skoutaris.
Yes, thank you very much. So just to sum up the points that have been made in the two previous sessions, I mean, there's no doubt that Scotland has the right to self-determination, but it's not quite clear how they would exercise it. I mean, it is clear in the sense that, you know, if Westminster allows them to do so, they can. But it's very, very difficult to do it unilaterally, especially in the aftermath of the Supreme Court judgment. Is there merit in proceduralizing the right to secession? In my work, I have argued in favour of that, because I believe that apart from the reasons that Dr. Reibel summed up, I think that proceduralizing the right to secession helps in the avoidance of a constant constitutional conflict. When it's not quite clear when and how this right will be exercised, we tend to have situations whereby this becomes an open wound. The sides all the time fight over the procedure. So I think it is important to actually clarify the rules that can lead to that.
Professor Henderson.
Yeah, thanks very much. So in the paper I submitted, it focuses entirely on public opinion, because it explores this understanding of losers' consent and the importance of process and procedure. So we know that an accepted procedure that builds trust and confidence in the democratic process is important. It's important that any democratic event is perceived to be both free and fair, and that is true for elections and is also true for referendums as well. But in the particular case of referendums, the binary and highly polarised nature of those referendums means that process is all that more important. When we study attitudes to process, we often look at attitudes to democratic satisfaction. And one thing we know, if we look at democratic satisfaction before and after referendums, the key determinant of losers' consent, the key determinant of democratic satisfaction and an acceptance of the result after the fact is how you feel about the process. We also know that all of this connects to a body of work that's being undertaken in Northern Ireland and also in Scotland about attitudes to process around referendums, because we think it's incredibly important that we identify beforehand a process that is seen as mutually acceptable to all sides.
Thank you. Professor Lookers?
Yeah, so I agree with everything my colleague said, and I think that from an international perspective, the 2014 agreement between the Scottish and British governments on the parameters of the referendum has been quite inspiring. So, in the context where the British government would accept that Scotland could have a referendum on independence, obviously would be unproblematic. Now, the question is, what can be done in the absence of such consent, and again, has been said, that's completely unclear. Now, I would be remiss coming from Canada if I didn't mention that, in both 1980 and 95, there were referendum on independence in Quebec, not in the absence of, not in the presence of opposition from the federal government, but in the absence of any explicit acceptance of such referendum, right? So both times the federal government implicitly accepted the legitimacy of an independence referendum by participating in the campaigns. And I must also say that, of course, I live in a federation where sovereignty is divided, power is constitutionally divided as well. That certainly it's the position of all Quebec political parties, and not only those who support independence, that the Quebec government can exercise its right to self-determination independently of the position of the federal government on that issue. So again, different constitutional context, different type of state. But I just simply want to mention that certainly is the political situation and the political positioning here in Canada.
Thank you. And by no least, but last, Professor O'Donoghue.
Thank you, and thank you for the question. And I also would agree with everything my colleagues have said previously. I think from an international legal perspective, the process, there are very minimal requirements, but any process that would be set up would have to facilitate a free and open decision-making process. So, I don't think that's a risk with regard to Scotland, but that would be the only international legal requirement, really, that it would be a free and open, fully democratic process. With regards to Northern Ireland, I think there is more detail, obviously, on what must happen, but I think there is a question of the degree of detail that wouldn't necessarily be there. For instance, the United Kingdom, generally Westminster, has to act with rigorous impartiality when it comes to a referendum on Northern Ireland, so therefore they cannot take sides on that discussion, which would be different to, I would suggest, what happened in Scotland as to regards to political parties and taking positions from London. So there is things to be thought about, also about the kind of the duties to act. In Northern Ireland, as Professor Henderson has already mentioned, public opinion, but we have some cases about what evidence the Secretary of State for Northern Ireland must take, and the courts were uneasy with giving a lot of detail. It will probably be elections mixed with opinion polls, but the amount and the degree, or like, does it have to be 5 opinion polls, 6, etc., isn't there? So I think, yes, I think process, as all my colleagues have said, are really important, but how much detail, how much you want to sort of put parameters around the ability to act, I think is still an important question. For instance, with regard to Northern Ireland, whether or not there has to be a referendum in the Republic, likely politically, yes, that there would, but legally it's an open question. So the degree to which you want to actually write down every element of it, because you could also, how much you specify can also then lead you into questions of judicial review, which have already happened in the McCord case in Northern Ireland with regard to what evidence the Secretary of State needs. So I think yes, but there needs to be a question, I think, about just how much detail you would want to have written down.
Okay. If I could ask a follow-up question, just on that to Professor O'Donoghue. Professor Skouteras mentioned the right to self-determination, but as individual citizens, with the organisation of the UK, Northern Ireland citizens have a completely different set of circumstances to get to United Ireland or whatever than citizens in Scotland, and again devolution is different in Wales. So is there a danger that citizens are left with different rights across the whole of the UK?
Well, there is a differentiation, and devolution already it does that. I think that's the big difference between the UK and when we talk about Canada and the Quebec version, is that there is a federal system, has divided forms of sovereignty. So devolution in itself is based on the idea. So if we say take the recent FWS case, the question was around equality. Northern Ireland has devolved control over equality, Scotland doesn't. So there already are differentiations between what citizens just can and cannot do. And international law itself really doesn't interest itself in domestic matters unless there is a violation of rights going on. With regard to self-determination, that is a collective right. So I mentioned the McCord case, and that was a judicial review, but that was a judicial review based on the processes the Secretary of State would take, not on McCord's right to self-determination. That wasn't touched on at all. So self-determination is a collective right of a people's. That makes it, from a legal perspective, much harder, much more difficult to bring before a court, because you as an entity, as a people having standing, becomes much more difficult. So I think, yes, there is a differentiation. It's also quite different because it's recognised that Dublin and the Republic of Ireland has an interest in how Northern Ireland is run. And obviously there isn't another sovereign state that has that interest in Scotland. So yes, there is a differentiation. There is a difference in what is recognised as an ability, or how you would process the right of self-determination. But the idea that Scotland is a people with a right to self-determination who have already exercised it in choosing internal self-determination in the form of devolution that it has chosen, that is recognised. But that next step, absolutely, there is a fundamental difference between Northern Ireland, Wales, Scotland and England.
Okay. Does anyone else want to comment on that? Professor Skouteras?
Just one point. I mean, I completely agree with what Professor O'Donoghue said with regard to how internal the right to self-determination is exercised. Just to point out that the UK is not the only place where there is differentiation about how the right to self-determination is actually exercised, right? If we think, for example, France, right? So we have the recognition of the right to self-determination with regard to New Caledonia, and we had those referendums, but this doesn't apply with regard to other nations and peoples that they might be there. So it's not unprecedented. I'm not saying that it's the best practice, but it's not unprecedented, and it's not something that we don't see somewhere else in the world.
Thank you. Mr. Brown?
Yeah, can I thank the panellists both for coming along today and for the submissions that they made. I have two questions, but if I get a chance I might come back. Subsequently, it's a follow-up to the convener's question and trying to draw out the extent to which the UK is so different from other jurisdictions, and not least in the way that it treats different parts of both its devolved areas and also, I don't know what they're called these days, dominions. Now, I'm struck that before the referendum that we had in 2014, we were told that Scotland was going to be the most powerful devolved legislature in the world. And I'm also aware that in December last year, a year ago, the UK government, by order in council, changed the constitution of the Turks and Caicos Islands to allow a law enacted by the legislature to make provision for holding a referendum on a matter of national importance. And then the second part of it was to say that this may result in a change to the constitution which results in independence shall be deemed to be a matter of national importance. So, giving the power to the Turks and Caicos Islands to hold a referendum and for it to have the effect of achieving independence. And if you think of the other ones, the other example we've just heard, I think, if I'm right in saying, in Northern Ireland, the criteria seems to be whether there's likely to be support for a united Ireland as to whether a referendum should be held. That's one of the things to be taken into account, whether the Secretary of State thinks it's likely to be supported. The exact reverse seems to be the case in Scotland, whereby it was felt by the UK in 2014 that there was going to be no prospect of Scotland voting yes. Yesterday we saw a poll, maybe today, again showing support, majority support for independence. That seems to be the motivating factor for the UK deciding whether to support a referendum. So it's just to see how, try and draw out unusual, asymmetrical the UK is in the way that it decides these things, because that eventually will tell whether it's sustainable or not. So I know these things are not a pattern across the world, it's not a consistent pattern, but the UK just seems to be way out there in terms of the inconsistency and how it deals with it. I don't know if there's any comment from any members of the panel. Maybe Dr. Rabel first.
Yes, thank you for the question. So the fact that these entities are treated differently by the parent or metropolitan state is something we see internationally as well, because it depends on the political interests and political will and constellation. So these, how these entities are treated is highly context specific. I would say you've described yourself the contexts that are different for the Turks and Caicos, for the situation of which I'm actually not that familiar with, so I wouldn't want to say anything about that. But it's true that if Turks and Caicos have a right to hold a referendum on the question of independence, but Scottish institutions in the current constitutional setups don't, then that's a discrepancy. And it's possible, of course, that in the longer run this may lead to a constitutional grievance, to political grievances. And here I would like to go back to what was said, to the opening question, that this is exactly why seeking agreement on a process before the question of whether or not a referendum should be held is so important, so as to reduce the amount of that grievance, to make some space to govern while opinions are formed, and also to make space for exchanging views for actual details on the outcomes, potential outcomes of any such question. So what should Scottish life in the Union look like? What should Scottish independence look like? And if the process question is removed from that, then there is more space to discuss potential outcomes. So it just, what you said in your question, I think, emphasizes that looking for a process that is agreeable to everyone has many advantages, I think.
And just if any other members of the panel want to come in, I suppose what I'm trying to say is, how sustainable is it if all the parties agree that Scotland has a right to self-determination, that's been accepted by all the parties, and yet there is no route beyond one party being able to say, no, it's not going to happen? How sustainable that is, I suppose, is the question I'm asking. Yep.
With regard to the, let me first take the Turks and Caicos point and refer to whatever has been said in the first session from Professors Tompkins and McHarg. I think what they said when they kind of emphasized that we need to differentiate between those what would be former colonies and the case of Scotland. But let me go to your main question, which has to do with, the UK as being a special case. I think that it is true, it's a special case, but this has to do very much with the basic features of this constitution, that it's a constitution of political constitutionalism, and the fact that basically the UK constitution can change with one vote in Westminster, right, with a majority of one. That gives incredible flexibility, and this is perhaps why, arguably it is easy for Scotland, in quotation marks, for Scotland to, to get an independence referendum in a way that, in the case of the Spanish regions, they would need a constitutional amendment. But at the same time, precisely because we are talking about a system of political constitutionalism, if there is no willingness and cooperation from the centre, that leads to constitutional grievances. And this is the reason why I think that the inquiry that you are doing now is very important, because I do think that we need to clarify the rules as to how these rights will be exercised.
Can I just come in on that point quickly?
Yeah.
So, from a public opinion perspective, we know that the Scottish electorate is roughly divided into thirds. So 1/3 want a referendum as soon as possible, 1/3 never wish there to be another, and 1/3 are in the middle. If we talk about the issue of a mandate, then the plurality position in the Scottish electorate is that it should be the Scottish government's right to call. But when we talk about when that referendum should happen, we have to distinguish between two issues. One is on timing, so when should that take place, ideally, and the other is on triggers. So what should be the trigger of the Scottish Government calling a possible referendum? And when we ask that question, we know that 40% of the electorate, this is by far the most popular option, believe that if there is clear and sustained evidence that independence is the preferred option. So very similar to what's the reference made about Northern Ireland in the Good Friday Agreement. And then when we ask the public, well, what would that clear and sustained evidence look like? It's around a third saying, well, just 5 polls showing 60% support for independence, and another third saying at least 2 years of opinion polls showing majority support for independence. So the public opinion gives us guidance here about how they understand possible triggers for a referendum. And the other thing on process I want to say, and I mean, André will contribute on this far more than I could, but we know the lesson we have from Quebec is that the referendum result in 1995 was very, very close, and support for independence remained very high afterwards, but then fell slowly. One interpretation of that is that external circumstances changed, economic conditions changed, and so people formed different opinions about independence. Another interpretation is that the entire procedural process in Canada and the Clarity Act and discussions about process and an agreed acknowledgement that should there wish to be a referendum, there was at least a process there by which to have one, might well have taken the sting out of support for independence. So it could well be that issues of process are important in and of themselves, but it is also the case that issues of process could well have an impact on how the wider electorate feels about constitutional change.
Can I bring in Professor O'Donoghue as well? Thanks.
Thank you. So I just sort of wanted to make two, three very small points. One of them would be around the idea, sort of the way that parliamentary sovereignty is sometimes framed in this process. Because obviously there's questions about UK constitution and parliamentary sovereignty is fairly unique in that sense that that is the ultimate authority within the UK constitution. But I do think the devolution unsettles that in some ways, because there was referendums and people have, through a democratic process, have chosen devolution. So there is while there is some scepticism around referendums in the UK, given the more recent history, that idea of an exercise that is of claiming internal self-determination, I think is very important. It actually has a much longer history within UK constitutional forms. So Northern Ireland chose Home Rule, which is basically devolution, and chose that for itself rather than joining what was then the Irish Free State, which at that point was a dominion. The other point I wanted to make was around the first breakup of the United Kingdom, which was the creation of the Irish Free State. And I think in that sense, it's important to see the mix of different elements of law that are used. So the process by which that happened was entirely unconstitutional if we look at UK Constitution alone, which actually the parameters would be very similar to what it is now, though the kind of core elements would be very, very similar. But you also have to layer into that the international law requirements and Ireland's claims to self-determination, but also recognition. And I think that would be important if Scotland decided that, you know, the processes weren't being put in place and more grievances grew and there was a move to make some sort of unilateral declaration. Those fail or succeed on other states recognising that unilateral act of self-determination, which sometimes succeeds, but more often does not. But I think when we think about that sort of the sustainability of the UK denying it, the UK has recognised Northern Ireland, it recognised it in 1921 for what was then the Free State in the creation of a dominion, but that dominion over time becoming entirely independent. So the UK is actually probably more familiar than a lot of other states are with processes of changing both internal and external self-determination through political negotiation, international law and domestic law.
Thanks for that. My second question really is, first of all, to say, I think when I studied parliamentary sovereignty and stuff like that, it was recognised, certainly by the lecturers I had, that it was mythical. I mean, the idea that the UK Parliament can legislate to award Scotland the World Cup next year is a nonsense. It's bound by international agreements and all sorts of other limitations at that time, the EU membership, for example. But if it's the case that the one thing it didn't seem to be bound by was public opinion, or what the people actually thought the Parliament in the UK can exercise its power in the face of public opinion. If it's the case, though, that we can't agree, as Professor Henderson has said, a process beforehand, and that seems unlikely if you look at the precedent, which was to agree the principle of the referendum and then agree a process. If that's not to be agreed, I still think we're underestimating the extent to which the UK is unique and irrational and has no basis in terms of principles or in how it deals with different areas in terms of these issues. But Professor Skoutaris, in his paper, mentions page 28, the limitations on the Scottish Parliament since the Supreme Court's ruling, but then says, within devolved competence, the Scottish Parliament could ask whether the people of Scotland support the Scottish Government entering negotiations with the UK Government for the issuing of a Section 30 order, as an example of ways in which this can be advanced despite the intransigence of the UK Government, which I think is really quite interesting. I just wonder if other members of the panel have got a view on that, or if there are other things which may be possible as well to progress the issue, if people can make sense of that. Maybe come back to Professor Skoutaris first, since it was him I quoted.
Well, thank you very much for referring to my piece of evidence. So, I mean, so this part of my evidence goes back to a discussion that you had in the first session and in the second session. In the first session, mainly with Professor McHarg, in the second session with Professor Renwick, where you looked at whether there's a possibility for a democratic trigger mechanism, right? And the problem that Professor McHarg, referring to some work that has been done by other people like Dr. Eustace, points is the problem of the union reservation. What does that mean? It means that pretty much after the judgment of the Supreme Court, in a way we are not sure whether it is allowed for the Scottish Parliament to actually do anything that would touch on the union between the UK and Scotland. So I try to, kind of create a probable legal argument about what the Scottish Parliament can do with regard to creating a democratic trigger mechanism. And I went back to the judgment of the Supreme Court. And one of the points that's made there is that, notwithstanding, the Scottish Government can still engage negotiations with the UK Government about Section 30. So what I'm saying is that perhaps a democratic process can be created there, whether it would be a consultation, a petition, as Professor Renwick said, or even at the extreme referendum, where the Scottish Government would be asking for the authority from the Scottish people to actually engage in this kind of negotiations, which will not be about the union between the UK and Scotland, but between England and Scotland, but actually it would be whether the Scottish Government has the power, the authority and legitimacy to engage in negotiations, to be given the right to organise a referendum. I mean, I'm not 100% that this argument would work in the Supreme Court, but it's as close as I can get in my mind with a democratic trigger mechanism that within the limits that are set by the judgment could work.
Thank you for the question. I also read Professor Scutari's written submission with great interest. And from where I stand, so I both agree with him that this would be basically the only legal avenue left, technically left, after the Supreme Court's ruling. I also have some doubts, so I read the situation a little bit differently as to how it would be received. I think negotiations are clearly possible, yes, as the Supreme Court says, as has been accepted broadly, I think, by everyone involved repeatedly. But holding a referendum on that would be seen by the Supreme Court, if it were to look at that again, as not pertaining to the Union, I'm not sure about that. Because negotiations is one thing, but holding a referendum, particularly in a political constitutionalist context, has a very heavy political weight, and so might still be perceived to be sort of circumventing what the Supreme Court has said before. And a worry could be that this entrenches fronts further. And so might not be, but I might be wrong about that. But that would be one worry to think about before embarking on that.
I just wonder, though, if thinking about that, how interventionist the UK government, with the backing of the Supreme Court, if that was the case, would then become to actually say in Scotland, you're not going to have a referendum even to discuss, in this case, Section 30 with us. I mean, if the state had intervened in the referendum that was held by Strathclyde Regional Council on water privatisation, the consequences, there are consequences for continuing to prevent any discussion of these things. It's not a zero-sum game, it stops there. There are consequences for doing that. I mean, for example, if the Scottish Parliament was to decide in its required majority to cease its term in order to force an election based solely on independence, how far can the Supreme Court and the UK government continue to go to stop this question being asked?
I mean, I wouldn't want to speculate on how far they would continue to go on that. I do think that the signal from the last ruling about this, from the independence referendum reference, was to say that these are not legal arguments that they are prepared to hear, but instead referring to the political processes. That would be my reading of the situation. And I wouldn't want to speculate on how far it would go otherwise.
I can speak to the consequences in terms of public opinion. So in addition to running the Scottish Election Study, I also co-lead the State of the Union survey, and we run surveys in Scotland, Wales, Northern Ireland and England, and look at attitudes to national identity and attitudes to governance, and how people feel the Union is running and how it should run. And one thing we have observed is an increasing level of what we would call ambivalent unionism within the UK, not just in Scotland, but in all four parts. So we have a question that we ask that asks whether people prioritise the Union as it is, whether they want independence for their own part, or they don't want independence for their own part, but if one or more other parts of the UK decide to go their own way, then so be it. So that's a kind of, I don't want to go, but if somebody else goes, that's fine. If you add together of those with a view, if you add together the proportion who want independence and the proportion who opt for this ambivalent unionist option, you are at more than a majority of the electorate in all 4 parts of the UK. So the first thing to note is that support for independence in Scotland is higher than it is anywhere else, but that does not mean that there is a considerable level of satisfaction with the union in other parts of the UK. And there's an incredible level of ambivalence, but also grievance, often with what is perceived to be Scottish access to influence and Scottish access to resources that is not appropriate. So we know that that's going on in the public opinion. And that's coupled with what has at times been a very muscular unionist approach from the UK government of either partisan stripes of late. And so these two do not sit easily with one another. And what we have noted is that as measures of muscular unionism increase, levels of ambivalent unionism also increase. So there's a direct relationship there in terms of how the UK talks about the union and whether it is perceived to be on transmit or receive about union benefits or problems with the union and the consequences of that across the UK, not just in Scotland.
Can I bring in Professor Lacour, please?
Yeah, so self-determination issues are almost completely about politics, right? And the situation that's occurring in the UK, in Canada would be nearly unthinkable if the federal government, if the government of Canada were to try to prevent the Quebec government from holding any kind of self-determination referendum. There would be such political pressure and such political price to pay that the government of Canada wouldn't even think of going in that direction. So there's kind of, certainly in Canada and Quebec, there's a natural political mechanism at work here, which translates into a Quebec government being able to really hold a referendum on anything at any time. Now, of course, the referendums in Quebec have not been as clearly on independence as was the Scottish referendum of 2014, and maybe that accounts for a little bit of the difference there. And 1980, the referendum in 1980 is especially interesting, I think, because it was meant to be a two-stage referendum, akin to the process that one of my colleagues was describing, insofar as the Quebec government first was asking Quebecers for a mandate to negotiate a new arrangement with Canada. And if that question had been answered by a yes, then presumably after subsequent negotiations, there would have been another vote. So that wasn't the case. That wasn't the structure for the 1995 referendum, but the 1995 referendum was similarly around a question that could be interpreted as being about independence, but could also be interpreted to be about other things. So I think the difference between the two countries, is in part the result of different political situation, and also maybe in part the result of the dynamics and the discourse around the question that's asked.
Thank you. Yeah, I think Professor Donohoe wants to come in too.
Yes, just very briefly. I mean, in order for international law to have any purchase in this scenario, if there was a consistent denial, and this accelerated to a point where questions of democracy were raised, it potentially could become an issue with international law, but that bar is extremely high. There was some discussion about 6-7 years ago with Catalan, because the Spanish government had started arresting people when they held a referendum and started imprisoning people, as to whether or not it was reaching the level of which international law should start to take note, whether or not there was an oppression of the right to self-determination. Now, scholars were mixed on whether or not they thought what was going on in Catalan was reaching that level, and obviously things have subsequently calmed down again. But there is things for international law to start, for the mechanisms to start looking. There would have to be consistent denial, and it would have to start reaching a very extreme level, because international law values territorial integrity more, I would say, generally when it comes to the actual laws that you can use over sort of explicit external self-determination. So international law would have something to say, but things would have to get very serious indeed before it would.
Thank you.
In terms of international courts, I remember before the referendum in 2014 taking evidence from Sir David Edward, who was saying that there was no mechanism to take citizenship away from an individual. And we talked about the circumstances, but I think what was said by Nicola Sturgeon at the time was, unless there was a significant change in circumstance, there wouldn't be another referendum. But of course, we've been taken out of Europe and we have all lost our European citizenship unless we've got lucky enough to have a grandparent or married to someone from Europe at the moment. So we talk about international law, but is there not a human rights issue here when things have happened to Scotland that was against the will and the democratic will of the Scottish people, but we still have a barrier to actually determining how we want to take things forward? I'm looking at Professor Donoghue, she's nodding her head, so maybe she wants to come in first.
So I think because self-determination is a collective right, it's not an individual right, it is very, very difficult to use international legal mechanisms, and that is quite intentional. States it's not in the interests of states that are recognised to allow mechanisms to occur. So there are instances where things have come before courts, the Kosovo opinion before the International Court of Justice, but that was an advisory opinion, or not an advisory opinion, but it was taken by another state, because until you are a state and recognised as a state in international law, you're kind of caught in a catch-22, because you're trying to act like a state, but if you're not recognised as a state, you can't do that yet. So it could be raised, you could go through the General Assembly, etc., but you'd have to get quite a number of other states to come on your side. So there is an element of peer recognition that is required in order for you to exercise that right of self-determination before court. On the human rights element of losing things like citizenship, there were a number of cases taken to the European Court of Justice of the European Union on the loss of citizenship that were all unsuccessful because EU citizenship wasn't equated. Citizenship is very much bound to sort of domestic sovereignty and the ability of a state to decide who and who is not a citizen. And that is being very stretched at the moment, because there is what would have been agreed a right not to be made stateless, for instance, which many states now are actually going against. So I think it is very difficult. The international law does not make it easy for people to take cases for any courts on this. International law is, I would say, relatively weak, and it is designed to be that, because the states that do exist have very little interest in helping parts of their territories break up and claim self-determination. The only area where international law was quite strong on this was on the decolonisation process following World War II, and that isn't fully sorted now. If you look at places like Western Sahara or Palestine, so international law is not useful in lots of ways from an individual level or even a collective level in trying to exercise those rights, unless things become really extreme. And I would say that that's unlikely to happen. Obviously, you can't rule anything out, but getting to the point where international law would take note, it is extremely high, that bar.
Thank you. Does anyone else want to come in on that point? No. Let's see. Oh, yes, please.
Just to reiterate what my colleague has said, international law is not where I would look for help in this. I don't think, for exactly the reasons that Professor Donoghue has outlined. Some cases from Catalonia were taken to the European Court of Human Rights and were also unsuccessful on human rights grounds. There was more sort of, the attitude of the central government was much less permissive than it is in the UK. So that just gives an indication of how much the situation would need to change for any of this to become relevant at all.
Thank you. Mr Harvey.
Thank you very much, Convener. Good morning to the witnesses. In several of the previous sessions in this inquiry, we've tried to, we've ended up in a conversation about whether particular ideas are merely political rhetoric or whether they have any substance that can be relied on, whether that's once in a generation or settled will of the Scottish people. You know, are these principles or are they simply political rhetoric? And I'd like to explore that question in relation to the point that several of the witnesses today have made, which is that everyone accepts that it is the right of the people of Scotland to make a decision about their own future. Several witnesses have mentioned this, that there is consensus around it, and that consensus is, you know, written down as recently as the Smith Commission, where all 5 political parties that were involved in that and both governments accepted that, well, I think they phrased it as nothing in that report should prevent the people of Scotland from becoming independent if that's what they choose in the future. So it's a little bit more nuanced, but it does frame it very clearly as that right sitting with the people of Scotland, not with anybody else. But is that simply a piece of political rhetoric which just happens not to have been contested by the political parties that are prominent at the moment? Or does it have any status in terms of a principle within the UK's unwritten constitution? Is it something that can be relied upon in any sense? And obviously I'm aware that I'm asking that at a time when there is a genuine threat that a UK government could be led by a far-right party, which we should be afraid of for many, many reasons, but also it wasn't involved in that process and would presumably argue that it can't be bound by a principle that had been agreed by other political parties. So is there any sense in which the UK government's acceptance of that principle has some status and can be relied on, or is it as much rhetoric as once in a generation?
So, with regard to the 2 concepts to which you discussed in the 2 previous sessions, settled will and once in a generation, I don't have much to add to what has been said. I think that there is consensus that they are pretty much political posturing more than legal benchmarks. I would distance a bit myself from the discussion that you had with regard to when we should trigger a referendum, when it's very clear what the result would be. I think there was at some moment a discussion in one of the 2 sessions. I think that I understand why, from a political stability point of view, it's beneficial to have a referendum when there will not be huge cleavages in a society. But at the same time, the reason why we have many times referendums is precisely to decide dividing matters. Now, on your question about is it also the fact that everybody recognises that Scotland has a right to self-determination and it lies with the Scottish people, is that also political posturing and nothing more? I completely appreciate the frustration that might have been created by the fact that it's not very clear how Scotland could actually exercise this right after 2014, and especially after 2016. But I don't think it's only political posturing, because precisely we had an independence referendum in 2014, and one should not underestimate the fact that Scotland, had a choice in 2014, and in a way, at a minimum, it creates a precedent that it is possible for Scotland to exercise this self-determination. And again, this is an important matter if one looks at it from a comparative point of view. There are not that many regions or nations within Western democratic states that have been actually... I mean, Quebec, again, of course, is an important example, but we have referred to many times already to the referendum of October 2017 in Catalonia, where you can see there how difficult it is, or the case of the Basque Country, or the case law that we have from the Italian Constitutional Court with regard to certain regions in the north, or the German Constitutional Court with regard to Bavaria. So it is not for nothing that Scotland has actually had this independence referendum. So despite the frustration, which I completely understand, I think we should understand the 2014 independence referendum as an important precedent about how Scotland may exercise this right to self-determination.
Any other witnesses want to comment, and specifically on
Professor Lacour
to what extent this principle that Scotland has the right to make the decision, to what extent could it be relied on in the circumstance where a political party came to power in the UK which disagreed?
So, Professor Lacour?
Yeah, I mean, I agree completely with what my colleague just said. I think we cannot lose sight of the fact that there is indeed substance here when you look at, at things comparatively, and see Catalonia, right, where this right is not acknowledged or recognized to exist by political actors, which leads to a completely different, and of course for supporters of secession, a much more difficult situation. So I don't think it's purely political rhetoric. I think there is substance there, even if it kind of still begs the question of how to kind of, operationalize such substance. So completely agree with that. Just wanted to say a quick word about the settled will. Certainly a bit of a peculiar Scottish expression from an external's point of view, and I understand it made a ton of sense in the context of the march towards devolution, but I don't think it makes a whole lot of sense when it comes to the issue of secession, because, well, for a couple of things. One, it's an often repeated line in the secession literature that there's never been a secession from a modern, advanced, industrialized liberal democracy. Partial exception, Norway from Sweden, 1905. But what that means is that it's really, really difficult, right, to convince citizens of such states, in absence of threats to physical security, to support independence. And then second, and relatedly, Scotland, like Quebec, are divided societies on self-determination, which means that, it's really unlikely that there can ever be a majority enough to be called, a settled will on a question such as independence. And at the end of the day, what the Quebec experience says is that, perhaps unfortunately, because those are important events, right? Independence referendum, they're snapshots. As Ailsa said, support for independence in Quebec has varied greatly, for example, after the 95 referendum, in the way that nobody had anticipated. It was seen by political actors and observers in 95 that there seemed to be this trend towards an ever-increasing support for independence, particularly amongst the youth. And that turned out to be not a trend at all, because support for independence decreased shortly after the 95 referendum, never to regain the numbers that it showed in 95. So in Quebec, after, now almost 50 years of secessionist politics in one way or another, we've never seen the settled will. And I don't think we'll ever see it. So I'm thinking that it's also unlikely to ever exist in Scotland on that question, of course.
Okay, bring in Professor Donohoe.
Just a few small points on that, and I agree with what's been said before. What I would say about the change of political parties is one thing that international law is not determinative as a right of self-determination is a international legal right. So it's not something that can be extinguished by a political party. Change of political parties. It's not in the kind of gift of the UK Parliament, to go back to the question of parliamentary sovereignty. It's recognition within the UK constitutional order that self-determination is possible and has been exercised by all of the devolved nations in varying different ways. In Northern Ireland, there was a Board of Poll in 1973, for instance. So there are lots of examples. So I don't think the change of political party can't extinguish that right. That right exists. I don't think now it might lead to a dramatic change in political circumstances, which might change the ability to exercise that right as something that international law might intervene in. But that is beyond my expertise as to how that might unfold. The second thing I'll point on the settled will is to go back to the Northern Ireland example, there is a provision that once a referendum is called, there can be another referendum 7 years afterwards. Now, that doesn't mean you have to have a referendum every 7 years, but that is a part of the UK Constitution that is in the Northern Ireland Act, accepting that will is not settled, that it isn't, that is sort of even the once in a generational, that also has no legal meaning or purchase. What is a generation? So there is a part of the UK Constitution that says after 7 years, a question can be asked again. It doesn't have to be asked again. Again, it would be for the Secretary of State of Northern Ireland to make that decision. But I think in reality, politically, what will probably happen is once there's one in Northern Ireland, the political parties that want independence would start saying, right, we need to have it now every 7 years. So I think that idea of a settled will, there is already part of the UK constitutional order that sort of accepts that isn't actual. There is no such thing as a settled will, for all the reasons my colleagues have already aligned, but because there is sort of this idea that after 7 years it would be possible to ask in Northern Ireland again as to what it would want.
Thank you. Finally then, if we accept, and I hope this is right, that we can continue to rely on the principle that Scotland has the right to decide, or the people of Scotland have the right to decide, then we're still left in the situation where we have the right to decide, but we may not exercise the right to decide. And that's the quandary that we find ourselves in. One issue that I've explored with previous panels, and to a mixed reaction, is whether, if the Scottish Parliament's ability to make a decision is not being accepted and the UK Parliament or government are unwilling to make a decision, is there some other way in which the will of the people of Scotland, not necessarily to decide yes or no to independence, but that they are ready to decide on the question of independence, some other way in which it can be expressed, whether that's some deliberative or participative mechanism on a formalised basis, or in some informal way that's not directed by or under the control of formal political processes. Would any of you comment on whether you see any potential in that space for some form of expression of the will or the readiness of the people of Scotland, other than decisions in one Parliament that's being told it can't decide and another Parliament that's unwilling to decide?
I think that's the focus of a considerable amount of work that's happening in Northern Ireland. And they're not quite at the point of identifying a deliberative process that might be the end result, but they are using deliberative processes so as to identify what that process might look like. So they're using citizens' juries, citizens' assemblies, and small group discussions to try and identify what might be a mutually acceptable process. What would it look like? But that's in a very different context, because it's in a context in which there is a reasonable expectation that a referendum might result at some point. So they're trying to identify a research programme that will help them to plan the very best referendum that they can in the eventuality that it happens. I think we're in a slightly different situation. In Scotland, but there's a considerable amount of research coming out of John Garry's team at Queen's, so I would encourage you to
bring in Professor Donohoe again.
Just to build on that, so there are a number of projects going on the island of Ireland. Some of them are academic-led, others are led by civil society groups or civil society groups with academics. You've got feminist groups, for instance, women's groups working on various activities, cross-border rural women's groups working on things. So there's a lot of grassroots work done, particularly bringing groups that disagree together. So there is lots of really interesting academic work on this as well going on, but I would also look to the sort of less formal spaces in which these conversations occur and happen, because I think one of getting people to think through the implications. I think one of the issues with the previous referendum with Scotland was the white paper and what it presented and its neutrality and what it meant, but rather people, because people, one way or the other, the more that they have felt that they are engaged in the process, including in constitution writing, which obviously is slightly alien to the UK in the sense of writing everything down in one place. Obviously, it is a documented constitution, but writing it down in one place, and that again makes Northern Ireland slightly different in that you are dealing with another state that has a fully documented constitution. But things like getting involved in the political discussion, but also the type of state that they would like to have, including in legal drafting. And obviously I'm in a law school, so this is the work that I'm more familiar with and have been involved in. But these are, I think, at both the academic level, the political level, but also enabling and encouraging grassroots organisations, civil society groups, to have those discussions about how they would go about thinking of themselves as an independent state, or even with regard to losers' consent, that even if you are pro-union, if it was to be an independent Scotland, how would you like it to be in order for it to make, what links would you like to keep with Britain? So, for Northern Ireland, the interest that Dublin can now exercise in Northern Ireland, that would then shift to London. So there is an acceptance there that London would still be involved with Northern Ireland in the way that Dublin currently is involved in Northern Ireland. So those kinds of thinking through what people would actually like, from very formal processes through, I think, to that encouragement of those kinds of more ground level discussions and engagement in thinking about what people would actually like. Or a further version of devolution as well, that there are these other options that people could consider as well, which I think are extremely important.
Okay,
thank you.
Professor Skrtaris wants to come in, and Dr. Riabla after.
Well, thank you very much. Obviously, I agree with whatever Professors O'Donoghue and Henderson have said. Now, the problem that you have also pointed to in the previous sessions is precisely has to do precisely with the cumulative effect of the case law of the Supreme Court, right? So, especially in cases like the Independence Referendum Bill, the Brexit Continuity Bill, the Children's Rights Bills, and the way that the Union Reservation has been spelled out limits the space, the constitutional space that the Scottish Parliament have to create this kind of consultative or this kind of democratic process to test the issue of independence. And I think that Professor McHarg in her evidence pointed to this problem. And this is why in my evidence I try to think whether there is a way kind of to circumvent it, right? So that's why I suggested kind of to move the posts, and instead of asking about the independence and about the union, to ask whether the government has the authorization of the people to engage with negotiations with the UK about allowing them to have a referendum. I appreciate what Dr. Riabla said, and I have the same concerns. I wouldn't be 100% sure that this would be a winning argument. But I think it is a possibility. And I also accept that, the Westminster can actually pass a law tomorrow and say, okay, this is out with the competence of the Scottish Parliament. There's no doubt about it. But I think that given the very strict limitations that the Supreme Court has allowed, other than informal processes to which the previous speakers have pointed, this is the only thing that came to my mind, what I proposed in my written evidence. Thank you.
Doctor.
Thank you. Yes, so I agree with what has been said, and would like to add a couple of points. First, there is a lot of merit in talking about these things, both formally and informally as well. And in the informal discussions are really valuable because they stress that something like separatist desires is not, and whether they actualize or not in an independent state, it's a process, it's not an event. Most of the time it takes a long time if it is to be non-violent in particular, right? And to emphasize that in that process a lot of things need to be considered, both about the process to get there and about what happens if an agreement mechanism, a referendum is triggered, what happens after that? These are valuable discussions to have. And the example I mentioned in my written submission from Switzerland, which is about the secession of one canton from another canton within a federation, is just is a good analogy because it actually happened in a democratic way. So it gives you an idea of all the steps that would be necessary in order, like if a referendum were to be held and then was that would result in a yes vote for independence, what you then need to do. And informal processes before a referendum is held are helpful not just to determine the process of how to trigger a referendum, but also to get inspiration from the people on what would happen afterwards, which may then change attitudes and may help with democratic certainty and accountability, which is what you refer to in the scope of the inquiry. So I think there are probably more informal processes are probably more important than legal certainty at this point, right? So I think that they would be really valuable.
Thank you.
Thank you. Are there any further questions from the committee? No, I think that concludes our questions this morning. I thank you all again for a very interesting session, and again for all the work that you did prior to this and sending in the briefings for the committee, and wish you safe journeys home and a rest, maybe if you're up in the middle of the night from Canada. So thank you very much again, and I close this meeting to the public. Thank you.